everyone, and welcome to another episode of Designing Justice. I'm Priyambada Shivaji.
And I'm Shreya Tripathi.
We are part of the Justice, Access and Lowering Delays in India initiative at the Vivi Center for Legal Policy. Through this series, we have been speaking to various stakeholders in the justice system to identify areas ripe for intervention and potential solutions that we could implement for building universally accessible, inclusive, future ready, and better courts for all stakeholders. Today, we're speaking with Professor Vijay Raghavan.
Professor Raghavan is currently working with the Center for Criminology and Justice, School of Social Work at the Tata Institute of Social Sciences. He is also the faculty in charge of Prayas, a field action project of the CCJ, which focuses on protection of rights and social re-entry of persons in the criminal justice ecosystem. He has been a member of multiple advisory committees and bodies, including the Advisory Committee on Prison Reforms for the Union Ministry of Home Affairs and the Justice Radhakrishnan Committee on Prison Reforms for Maharashtra. He has also been involved in training of police, prison, and judicial officers at both the state and national level on gender, human rights, prisoner rights, correctional laws, etc.
This interview today, we will be delving into the various ways in which courts, which are sites of contestation and reform, affect persons, particularly in the criminal justice ecosystem. We seek to understand how the system can be strengthened to ensure that courts become safe and non-intimidating spaces, which can aid in rehabilitation and support in the long run as well. Sir, this will be a free-flowing discussion, and we'd like to begin with. Could you please take us through the journey that an accused person faces in the criminal justice process, and how courts in this process are viewed by these persons in this overall journey?
Okay, uh, so I'll largely focus my understanding of the situation based on people who remain in custody, because there are two categories of people that we talk about. One is those who get bail at the first instance of arrest. There are people, a smaller percentage of people who get bail even at the police station, which is often known as station bail. And then there are people who may get bail after being produced before the court, which is within 24 hours when they are produced in court, and then they get bail at that stage. We don't get access to these people because we are not working at the time of first arrest or at the time of first production in court, because our intervention is largely in the prison, where we are interacting with under trial prisoners. So our interaction is based on the fact that these are people who have completed a certain number of days in police custody with the permission of the court, and after that they have been transferred to judicial custody because the investigation part is over, and now they are awaiting trial to start, in fact awaiting for the charges to be framed from the first place. So whatever I share with you would be based on that group. So therefore it may not be generalized for all kinds of people who get arrested and are processed through the courts of India. So coming to this group which I am talking about, most of the people that we come across are from very marginalized backgrounds. If you look at Prison Statistics India report, you will see that more than 85% of them are from SC, ST, OBC and minority communities. Secondly, if you look at their educational profile, you will see that more than 27% are non-literates, and around 40% of them have studied less than class 10th. If you're looking at income levels, while there is no documentation of income levels in PSI data, that there is some kind of anecdotal evidence, as well as one particular study that we had done based on the people with whom we have interacted over a period of 2018 to 2021. This was a study done jointly by Prayas and Fair Tile Program Project 39A NLU Delhi, which is now of course called the Square Circle Clinic at Nalsar. And it was part of that report that it came out that most of them, more than 70% of them if I remember right, their annual family income was less than 1 lakh. So again, you are talking about people, who are coming from the really marginalized sections of society. So how does the court look for a person like this? And I would also add to this my own personal experience of having been a social worker in Prayas before I started, teaching here at TIS. I was a social worker working in Prayas from the time Prayas was started in 1990 and till the time that I left Prayas full time and moved to a faculty position at TIS, that was in 2005. So 15 years I have worked in the field, firstly as a social worker and then as a coordinator of the project. And that experience, and plus my own PhD experience, because I did a study on youth arrested in organized crime. That was the subject of my PhD, for which I did data collection in the period of 2008 to 2010. And that was another period when I interacted with a lot of young people who were in prison. So I'm trying to construct the story from the perspective of these categories of people that I have interacted with. So how does the court look to a person like this? So first of all, most of these people whom I'm talking about, and again I'm putting a caveat that this may not be true for all people, that when they get arrested, very often they may not know exactly for what crime they have been arrested. They can get picked up from the road, they can get picked up from their residence, or they can be picked up from their workplace, etc. And when the police has suspicion that somebody is involved in a particular kind of offense, then they will get picked up, and of course police has every right to pick up people whom they suspect to have committed an offense. And that is why we have the checks and balances in our justice system, that after you pick up somebody, you have to produce that person within 24 hours before a court, so that the court can look at whether the arrest is valid or not. Now after arrest, whether you have been informed about the grounds of arrest, there is a pretty good chance that you may not be informed, because the more information that you have at your disposal, the more likely you will be able to do something about it. But if you don't have the right kind of information, then you are in a bewildered state, and also the shock of arrest and things of that sort. Whether your family can be informed, whether your family can come and meet you, whether you are allowed to have food, home cooked food, all these are small matters. Whether you can somebody can come and give you a pair of clothes, because you may just have one pair of clothes. All these are factors which are very well laid down by our courts, and also the police manual, for example, has many of these provisions. But there is absolutely no guarantee that these would be followed, and it would depend on the caste, class, gender, class you belong to, that and your knowledge and information at your disposal, that you might get access to all of this. Or it could also be that the police have a categorization of their own of who are hardened offenders, or who are criminal type people, and then those who are circumstantial criminals, those circumstantial offenders. They might be more kind towards that category of people whom they think are मजबूरी के वजह से हो गया है, या उनके हाथ से हो गया, and it was a matter of passion and things of that sort. They would be treated very differently from somebody who is known in the eyes of the police as a regular offender. So therefore, the chances of what kind of information that you have at your disposal at the time of your arrest is a very uneven kind of a picture. Then your first interaction of some kind of checks and balances happens when you are produced before the court, and that is usually within 24 hours. Of course, unless there are places where it's very far away from the court, and it may take more than 24 hours to reach the court, and there is provision in the law for that as well. Now, when the person is being produced before the magistrate, that I think is the most crucial point in terms of what kind of actions can be and should be taken at that point. Now, typically, again, at that point, you will have two categories of people: those who have a lawyer with them appearing in the court at the time of their first production, and those who don't have a lawyer at that point. Now, there are provisions in the NALSA SOP that you're supposed to have a remand lawyer in court. So for those who don't have a lawyer, the remand lawyer will appear on your behalf, will ask you whether you need a lawyer, and will sign a wakalatnama and will appear on your behalf. Now, the experience that we have had is that most of the time, these people who don't have a lawyer of their own, the family members are often given a contact by the police station itself to go to XYZ lawyer, and they are told to pay so much, and the folklore is that probably police also gets a cut from that entire system, the lower level at which we are talking about, and then these lawyers may or may not appear at the time of first production, because they may take the money and just vanish. So therefore you are left with a situation where this person is bewildered, first of all, doesn't know what's going to happen to this person, and yet at the same time may not have a lawyer at the time of first production. Now, in this case, the role of the judge or the magistrate becomes very important. What kind of message is the magistrate or the judge able to give to this person? The first point that is whether the magistrate even interacts with that person. Does he ask him, what is your name? Where you? When were you arrested? What time were you arrested? Do you have a lawyer? Has your family been informed? Were you treated with any kind of force by the police? Do you have any ailments? Do you have any kind of illness which needs immediate medical treatment, etc.? These are very basic questions that the magistrate or the judge is supposed to ask. And based on the answers, the judge is supposed to make provisions for that. So if he has an ailment or an illness, then the judge can order for a medical checkup to be immediately carried out. And in any case, under the DK Basu guidelines, medical checkup is supposed to be done every 48 hours. So immediately the judge can order, the magistrate can order that he or she be taken to the doctor, the nearest government hospital, and treatment be started. Or if he or she is a regular patient of some illness, like could be blood pressure, diabetes, a heart ailment, etc., then those medications should be made available to that person. There is so much that a magistrate and a judge can do at that stage. So this is on paper. Now we come to what happens in practice, and the reality of the whole situation is that these are judges who have very heavy caseload. They have to attend to, these are called as remand proceedings, and after the remand proceedings are over, then the trial matters are taken up. So sometimes you find that the remand matters happen in the morning, and the second half is for the trial matters, or vice versa, that the first half is going for trial matters and the second half the remand matters are going on. Now, if you look at the caseload on a particular judge, the caseload is so I would say inhuman that there is no chance that the magistrate is going to spend more than 2 minutes per case, unless there is some very visible behavior or something that he or she sees where it catches their attention, and then they start asking questions. But normally what would happen is, at the first remand, as soon as the person is produced, the police will of course submit the immediate documents where they will make a claim that this person should be kept with us for the next 5 days, 10 days, 14 days, whatever the maximum is, 14 days. So they may ask for custody, and the police and there will be some conversation that will go on between the public prosecutor and the judge. And if there is no lawyer at that stage, then there is no defense lawyer to counter what is being discussed between that public prosecutor and the police and the judge. And based on that prima facie assessment, where the judge or the magistrate has to make a spot assessment as to what needs to be done now, he or she will remand for further custody, either 5 days, 7 days, 10 days, whatever it may be. Very rarely at the first production, the judge or the magistrate may say, I don't see any reason why this person should be kept in custody, and I'm immediately releasing him on bail. And there have also been cases where the judges discharge the case straight away, saying that no, there is no substance in this case. But that is a very rare occurrence. In most cases, the person would get custody. If it is a bailable offence, he would also pronounce bail. Either in the first production or maybe in the second production, he would pronounce bail. But otherwise, in non-bailable cases, of course, the person has to wait. Mostly, typically, only after the charge sheet is filed that the lawyers would move for bail application. Till then, the lawyers also feel that it's not useful to file for a bail, unless you have like a battery of lawyers and you have a very good lawyer who's able to fight. So the point I'm trying to make is, from that point onwards, the presence of a lawyer makes a huge difference to the way in which the case is going to go on. This is as far as first production is concerned. Then after that, the second important stage is when you are going to be transferred to judicial custody. This is assuming you have not been granted bail and you have not gone out on bail as yet. So there are many people. So if you look at the percentage of people who end up in judicial custody, it's a fraction of the total number of people who get arrested. I don't have the figures right now at the back of my head, but I know that it's a very, very small percentage of people who finally end up in judicial custody. I think it's somewhere in the region of 10% or somewhere around that. I mean, you might be able to dig it out, and it's very easy to dig it out. But just for the knowledge of the audience, most of the people would not come to judicial custody, which means prison. Many of them get out before they reach the prison, right? So now we are talking of what you're seeing is your layers of marginalization. So first is, and at first production, you have a good lawyer, chances of your extension in police custody will be dependent on how good the lawyer is and what kind of arguments the lawyer makes. And that lawyer will make every effort to keep the police custody as few days as possible. He or she will fight for why 3 days, why 2 days, and the prosecution will say why they need. Right. And then that good argument will help the judge to take a decision in terms of what's the number of days. In the absence of that kind of a good lawyer, or even in the presence of a remand lawyer, which is provided through the DLSA, the chances are that there's nobody fighting for you. So it will purely then depend on the discretion of the judge, what he or she thinks, how many days police custody to be given. And at the stage at which the judge feels that now I will not give any more days for investigation. In any case, cannot be more than 14 days. But if it is less than 14 days, 10 days, 8 days, the judge decides enough is enough. I am transferring this person to the judicial custody. Once the person goes into judicial custody, until the time the charges are framed, and that could be a pretty long period. It could be 3 months. It could be more than 3 months. It could be 6 months. Again, depending on the seriousness of the offense, right? Like if it is a magistrate's court case, then maybe within 3 months, 60 days is when the charge sheet has to be filed. So maybe within 2 months, the trial, the charges would be framed. But if it is more than that, if it is 90 days, which is the mandatory period within which the police has to file the charge sheet, or in serious offenses 120 days, and in some offenses I think 180 days. So that whole period, number of days within which the charge sheet has to be filed, the police will keep taking more and more time to complete the investigation. And fine, that is within their rights. And then the question will come about in terms of the charges to be filed. This period, from the time the person has entered the prison as judicial custody till the time the charges are framed, where the judge actually asks the person, these are the charges against you, do you plead guilty or not? That is the charge framing stage. This entire period is known as the remand stage, the remand period. Now in this remand period, that person is supposed to be produced every 14 days so that the judge can see the person, at whether that person is in healthy state, okay, whether the person has anything to say with regard to his situation or her situation. Like in the case of women, they might want their child who is below 6 years of age to be brought inside with her, and for that the only time she can say that is when she's produced in court, and request the magistrate that, I want my child to be with me because I don't have anybody else to look after my child who's below 6. Or if the child is above 6 and she feels that the child is not being taken care of at home, there is nobody to take care of the children, she can tell the judge that please do something about it. The judge can then order the police to produce those children before the child welfare committee, so the child welfare committee can take whatever decisions are required. So there are a host of things. I may be unwell, and I need medical treatment, and I'm not getting the kind of treatment that I think I deserve while from the prison authorities. I can tell the judge that I'm suffering like this, and I'm not getting proper treatment, and so the judge can order that the prison authorities must look into the treatment, or they might even order that, okay, send that person to the nearest civil hospital where a better checkup can be done. There can be n number of things that I would like to communicate with my judge, nothing related to the trial because the matter is still at the remand stage, but there are many other things. I may have my personal property still lying with the police station, and I want that property to be transferred to judicial custody because I'm not sure after I get released whether I will be able to go to the police station and recover my personal property. Personal property could be your wallet, your gold chain, or anything of that sort, cash, or your identity documents, your Aadhaar card and things of that sort. So this is that period when every 14 days you're supposed to be produced. Now, since last few years, at this stage, most of the time they are being produced not physically but through video conferencing. So that system has come into place now, technology, because for the system this used to be like a real headache because no concrete outcome is taking place during this period, and it's just a waste of resources where you are arranging vehicles and so many constables who have to be taken, and they have to come, they have to pick up, and as it is, there's a huge shortage of police escorts. As per the CRPC and now the BNSS, the job of escorting prisoners to a hospital or to court on their court dates is the job of the police. Now for the police, this is really not really their work. If you look at their overall workload, they don't think this is so important because they have law and order functions to take care of. There can be a bandobast happening, a VIP person has come, the entire police force will get redirected towards that. So always, if the prison authorities are asking for 10 people to be produced, ultimately only 5 might get produced or 6 might get produced, and this is particularly true in cities, in big cities. In a small town, maybe not so, but in a city like Mumbai, for example, there is always a shortage of police escorts, so they were not being produced. And then the courts came up with this innovation, which was then incorporated into the CRPC, that people can also be produced through video conferencing. In fact, now even trials can go on through video conferencing. Earlier, it was only up to the charge sheet filing and the charge framing stage, but now even trials can take place. But I have not seen too many trials taking place through video conferencing. But definitely at the remand stage, they are being produced through video conferencing, which means that when you were produced through physical production, you would be taken to court. If not 14 days, at least once in 1 month, once in 2 months, at the most once in 3 months, because there would be many times when you would not be produced. Instead, just your remand warrant would be taken to court and the judge would just sign on it and give another 14 days. So no physical production. But at least once in a month, 2 months, 3 months, physical production would take place. When that physical production would take place, this person would get an opportunity to meet his lawyer or her lawyer. Person would get an opportunity to meet his or her family members, which otherwise they can meet through prison mulaqat, no problem. But prison mulaqat is more cumbersome than the court mulaqat. Prison mulaqat means you need to show some documents, there's a procedure, you have to fill up the form, etc., etc. Whereas in court mulaqat is just that, usually the constable would allow the person to meet their family members, maybe a little bit of money that might get exchanged, but otherwise, it's not such a difficult process for family members to meet the accused in the court environment. On the way to court, being produced in court, or in the court lockup, that's where the family members would be able to meet. So meetings with families and meetings with lawyers, and also getting a sense of meeting public in general, a sense of the open air and things of that sort. So it was also important from a mental health point of view, that the person has contact with the outside world. Now with the video conferencing facility coming in, they are completely inside the prison for long periods of time without being produced physically. Then comes during this phase, there's not much happening in this person's life. He's just waiting for the trial to start. If he has a lawyer, then at some stage bail application would have already been filed or would have been heard, rejected, or bail granted, but still not being able to go out because no sureties, etc., and a number of other things. Then comes the charge framing stage. Now the charge framing stage again is a very important part of the whole trial process, when the person is told that these are the charges against you, and so you plead guilty or you don't plead guilty. Now again, there are a host of factors when a person may or may not plead guilty. If you have a good lawyer with you, the chances are that you will not plead guilty. You will say, I'm innocent, because your lawyer is there to coach you, your lawyer is there to tell you what you should do and what you should not do, and you also have family support. They are coming for mulaqat on a regular basis. Also, they are calling you up, because now phone call facilities there almost in all prisons of India. So they are calling you. There's video mulaqat that is available, so you can talk to your family members through video, etc. So there is one category of people for whom there is physical mulaqat happening, there is video mulaqat happening, there are phone calls happening. There's another category of people where this is not happening. So they are inside, their family is not in touch with them, and they are just spending time inside, hoping that something might change. You have legal aid lawyers coming in now, and that's I would say that's an improvement in the system, which was not so active. Now I see more and more this, the legal aid clinics actually functioning. There's been a lot of pressure from the courts, Supreme Court, various directions, and particularly, for example, the regarding inhuman conditions in 1384 prisons of India. That was quite a long pending, going on for many years, and that has made some difference. Legal aid clinics by themselves are more active. You have paralegal volunteers appointed from within the prison population who stay with the prisoners, and so therefore there's a little more awareness about what is going on in my case. But nevertheless, and also you are now having a lot of people asking for legal aid lawyers, as that was not the case earlier. I mean, I'm again limiting my discussion to what I have been witness to. I cannot talk about what is going on in other states of the country. But I generally speaking, I can make a statement. The new system of legal aid defense counsels having come in, which is a different system than the legal aid lawyer system that used to be there, where private lawyers would be appointed on an honorarium basis. You now have full-time lawyers who are appointed on a salaried basis by the legal aid authorities, and the quality of legal aid has, I think, improved as a result of this innovation that has been brought in by the NALSA. So you have legal aid lawyers coming in, you have LADCs coming in, you have paralegal volunteers there. There is a separate room in the prison on legal aid. There are some boards and things about what is you are entitled to. So there is a little more, awareness about, your condition, your status, etc., etc. But nevertheless, you will still have a category of prisoners who would feel that rather than wait for the trial to get over, let me just plead guilty and get out. And there are other prisoners in the barrack who would advise him or her to do that by making a kind of a calculation that what is the offense for which you are arrested. अच्छा, चोरी के केस में आया है, कितने अमाउंट का चोरी था? 10,000 का अमाउंट था. अच्छा ठीक है, तू 3 महीना वेट कर ले, 3 महीने के बाद गुनाह कबूल कर ले तो छूट जाएगा. So very often even judges are sometimes, magistrates are in a sense luring the person to plead guilty by saying, अगर तू गुनाह कबूल करता है तो तेरे को मैं अभी छोड़ दूंगा. So what is happening as far as the judge or the magistrate is concerned, his or her case is getting disposed of. So it's increasing their disposal rate, which is one of the parameters based on which their performance is assessed. So they want more and more cases to be disposed of. So this is like the whole system is trying to do this, particularly in petty and less serious offences. If it's a serious offence, a sessions charge case, then neither the accused nor anybody would say you plead guilty. But if they are magistrate court matters, then definitely there would be this situation where prisoners would encourage them to plead guilty. Prison officials would tell them, अंदर क्या क्यों सड़ रहा है तू, गुनाह कबूल कर, बाहर निकल. Courts would tell them, तुम अभी गुनाह कबूल करोगे तो अभी तुमको मैं छोड़ देता हूँ. So that means there is one kind of justice for these people, and there's another kind of justice for people who have access to family, who have access to resources and access to lawyers. So the entire system, which on paper looks very good, it gets broken because of, not for anybody's personal reasons, but because of systemic gaps. You don't have enough judges, you don't have enough prosecutors, your legal aid system has still a lot to be left to be desired, and your resources, courtrooms, court staff, all of this is short staffed. So therefore the final load of this is being taken on one category by one category of people, and the others, the more resources you have, the better are the chances that you'll be able to access those rights which are enshrined to you on paper.
Right. So, thank you so much for saying this. There are multiple follow-up questions that we have from this. But perhaps we'll start off with one of the things that you mentioned, right? About the mentioning in front of the court. Now, I understand. So, two things from that. Like you said, now many of these appearances are happening online or through video conferencing facilities. So, in your opinion, how well are these working actually? I mean, for example, we know from some practicing lawyers, also lawyers who are persons with disabilities, that a lot of times when they're appearing through a video conferencing or they're using some of these facilities, it doesn't always work very well. And this is with people with private connections, right?
Yes,
And we are
yes.
talking about a government connection at a prison facility. So how well does that work? And as much as I understand that it's the lawyer who does most of the talking, but also how much is the prisoner who's, or that person who's in the system, who's already reeling with, like, the burden of being in the system, how much does he or she feel that that they are being heard? uh I'll just second part of this being when they actually come to court. Many of us who have been to court, especially criminal courts or like slightly bigger district courts, we have seen that one bus coming with like a bus full of people from the prison, all of them tied to each other, and like that journey that they have to go through. So in your opinion, like how does this repeated exposure in both instances, right, where you are not being able to get heard perhaps in a video conferencing situation, or when you're being paraded to the court in front of everyone, how does that kind of affect a person's, say, perhaps mental health, sense of dignity, or like just how to deal with the system? How does it motivate or demotivate?
See, dignity is getting compromised from the point you're getting arrested. For example, if you belong to a certain category of people, which means below a certain class, the moment you get arrested, you'll find that their chappals are taken away. Okay, just that is the first point of the messaging that starts, that you are, let's say, less than human in some way or the other. Okay, so at every point, if you are asking for something, the response that you will get is tere baap ka ghar nahi hai ye. Okay, you are an accused right now, you better behave yourself. Okay, so when you're talking of dignity, that dignity is compromised at the arrest stage, dignity is compromised at the time of investigation, dignity is compromised if you look at the situation of our police lockups, especially for males. Dignity is compromised when the search procedure takes place when you enter the prison, where you entirely, the strip search that takes place. Dignity gets compromised when there is a search, there is a what is known as a JALDI, where the entire all the wards are searched, because if suppose they've got some information that drugs have entered, or there is some mobile phones are inside the prison, so there are time to time these are called security reasons, and that's a job of the prison authorities. They have to do what they have to do, but in that process somebody's dignity is getting compromised. Your clothes are thrown around, you have to pick them up and put them in one place, so the question of dignity being compromised is a gradual process by which you get used to this. That's the point I'm trying to make. You are shown your place, and you slowly accept that as this is my place right now. I mean, I live another life when I go out, but right now this is my place. I need to make compromises. I need to make relationships. I need to make my life a little better than what I am. So I will do all those things which if I do, my life will get a little better. I will work in certain sections where if I work there, I will actually earn a favor from the authorities, so that I'll get maybe get better food, or access to something else, and things of that sort. So dignity is getting compromised, and one is slowly getting socialized to this idea of dignity being compromised. So when you ask me, when they are produced in court, would there is dignity being compromised? Yes, of course there's dignity being compromised, but any day they would prefer to go to court than to be produced through video conferencing, because of the fact that you get to meet people outside. You get to meet your lawyer, you get to meet your family, you get to see things, you get to just get fresh air, which is also very important. Though I would say that Indian prisons that way are unique in the sense that every prisoner gets a bit of fresh air every day, because there is something called khula time and bandi time. And khula time is between 6 in the morning and 12 in the afternoon, and then again between 3 in the evening and 3 in the afternoon and 5:30 in the evening, when they are inside the prison but within a particular compound wall. So every barrack has a compound wall, so they are getting fresh air. They are moving around within that premise, which is not the case in your so-called American or other Western prisons, where everybody is put in separate cells, and they don't get access to fresh air as easily as Indian prisons may be overcrowded, and maybe not so hygienic, and sanitation may be a problem, but they are at least in touch with each other. They are talking to one another. They are fighting with one another. They are getting a bit of fresh air, things of that sort. So anyway, that's just a little bit of a divergence. So, but video conferencing, the chances of being able to communicate what you want to communicate reduces that much. I'm not saying that when they are produced in court physically, they get a chance to talk to the judge or the magistrate. But if there the chances are 10%, here it becomes 5%. Because, sometimes the connection is not working. Sometimes the video is not properly working, Many times there are not enough video conferencing facilities in the courts. So it might be in one room, and the magistrate has to find time to come there. And sometimes in the whole day is so busy that he may not be able to come, and then ultimately he'll just sign the warrant for another 14 days or whatever it might be. So I would say any day you can ask somebody who has been through the system that they would prefer to be produced in court than to be produced through video conferencing.
I think that's something to keep in mind, because the judiciary keeps, wanting to barrel ahead with more technology adoption and reforms, but we need to keep in mind the actual impact that it results especially in these
Yeah.
situations.
From a systemic point of view, this is a very small cost to pay, because they are looking at it in terms of how much money is being saved, how much time is being saved, how things are becoming faster now. So I mean, it's not as if we haven't brought it to the notice of there are the only time when video conferencing was introduced for the first time in Maharashtra, it was through a PIL that was going on at that time, called PUCL versus State of Maharashtra, clubbed with another PIL called Rajendra Bidkar versus State of Maharashtra. This was in 2005, and that's the first time when this issue of police escorts was brought up by the petitioners. I was a member of a committee set up by the High Court for suggesting recommendations of what can be done to improve prison conditions. The petitioners had raised this issue of police escorts, lack of police escorts, and therefore prisoners. That's when the Chief Justice at that point suggested that we should start video conferencing. And when we expressed apprehensions and fears, we were told that you can't technology. We can't say no to technology. We have to move on. So we were told to come up with some guidelines to ensure that some of the issues which we were raising, which he was conscious about, could be incorporated into the video conferencing production system. And I think it's the only set of guidelines that exists in India anywhere, where the Bombay High Court guidelines are there in terms of what are the minimum number of kind of precautions to be taken when people are being produced through video conferencing. For example, one of the things that it says is after every 3 video conferencing productions, there should be 1 physical production. Then it also says that if a prisoner demands that he or she should be produced through physical, the court should consider that. Okay. It also says that a legal aid lawyer should be present inside the prison when the person is being produced through video conferencing. So number of such guidelines have been issued, unfortunately not fully being followed, but it's there for anybody else to look at.
Actually, this also leads me to another question that we had, sir, in terms of the efforts that you had made to raise these concerns and to be able to produce these safeguards, these guidelines. I think sometimes, especially as people who are a little external to the system, as policy professionals such as ourselves or academics, etc., we see all of these issues, we do all of these studies, but we're not sure of the correct institutional frameworks that we could use to encourage the judiciary to take greater ownership of these concerns. And I think one way is obviously, of course, the litigation route, as you mentioned, filing PILs, etc. Would you suggest from your example how else we can go about raising public awareness of this, and who should ultimately be made responsible for ensuring that these are actually taken up from the judiciary's point of view?
That's a difficult one. Uh, I don't have any clear answers to that. I just feel that there are multiple ways by which you have to keep trying to do this. You have to, first of all, I think most importantly, you have to keep working at the ground level, because only when you keep working at the ground level, you get to know what is going on, what is happening at the ground, and you also end up providing relief to X number of people in that process, which is nothing but a drop in the ocean. But in that process, you also get to understand the system in its deepest level, at its deepest level, and also understand what are the limitations that the system is facing. Because a lot of system bashing doesn't really produce results. I mean, I'm firmly of that opinion based on my work experience and Prayas's work experience, that system bashing doesn't help. What we need to do is to also look at that everybody in the system is not evil and getting sadistic pleasure out of making lives difficult for others. I think a lot of people are just trying to do their job, and they're trying to do it as well as they can, and there are bad apples everywhere, so including our sector. So we can't claim any kind of moral high ground when it comes to that. So my thing is that you have to work at the ground level with the people who are trying to process people within the system, so that you get a very nuanced understanding of where the problem lies, and in consultation with them you also come up with suggestions. So for example, when this video conferencing thing came up, we didn't oppose it tooth and nail, because we knew it was going to come. We said, okay, let us try to see if there can be some precautions that can be taken. And when we took that position, the court was very happy to give us some kind of leeway, and said, okay, you come up with suggestions in terms of what can be done. So one is that, working at the ground level, working with the system, not necessarily looking at them as adversaries, but as people who are also engaging with a particular issue, and they are a different kind of professionals, you are a different kind of professional, and we need to work together. That is point number one. Second one is, I think there has to be a culture of encouraging different kinds of research within this field. to come up with solutions, and this unfortunately we don't see that much of this happening unless you come from a very privileged kind of a space where you are part of a like an academic institution very well known like TISS for example, or some national law university, etc., etc., or some very well known organization, things like that. Then you are able to do research. But the ordinary academic space, if you try to do a research, you will be stuck with permissions. There will be issues of access and things of that sort. So the research is not taken that seriously, unfortunately, in our country in terms of what research can contribute to. Third is, when you do a research, then the question is who's listening to you in terms of your recommendations. So that becomes the next big challenge. You have done a research, you have come up with some suggestions, there is nobody to listen to you, to even challenge you and say your recommendations are rubbish. We are fine with that, but we have to go trying to convince people that these are we did a study, these are our recommendations. At the most we'll be told yes, we'll look into this, but then again those people to whom we are going, they are not the people who are taking decisions. Maybe the decisions might be taken place at the very top level, on something where there are much larger factors at play. Whether to bring in prison reforms is not the priority of a government. The priority of the government lies somewhere else. It lies in probably improving our education system or our healthcare, or looking at cash transfers and things of that sort. So in that entire environment, how are you going to put your two-bit thing and say, please look at this as well? Okay. So that is a big challenge that you face. And fourthly, media is not very easy, even when it comes to trying to put these kind of issues, because we are actually kind of raising issues which are not sensational. We are, if the media will pick up something if there is some sensation in it, in terms of a serious or a gross violation of human rights has taken place, and things of that sort, or there is like something which is awfully wrong with the system, and that needs to be, that they will pick it up. But if you are talking about a systematic way of trying to bring about a change, and this has come out and these are some good things and these are some, then it doesn't give that kind of leverage for the media to pick it up. So that's another issue. And our way of working has been largely working at the ground level with the system, picking up issues from there and taking it up with the higher authorities, right up to the say the Home Secretary level, or the NALSA or the SALSA executive chair level. So take it up as high as you can through a continuous process of engagement, not a one-time thing, but to keep going repeatedly on the same issue or on multiple issues till they become familiar with you as a serious organization which is not interested in publicity, but it interested in change, and is willing to work with the system, and is not only asking for some kind of ideal solutions. That's one. Two is to try and create awareness in the media by writing, either by writing yourself or getting journalists to write about issues that you care about, and then over a period of time you have built a small ecosystem of a few journalists who write about things that you ask them to write on. And thirdly, I think what has worked for us has been also the courts asking us to do certain things. So for example, as an academic institution, part of an academic institution, we have never filed a PIL in our entire journey, but we have always been invited by the courts to contribute, to be a member of an expert committee or give suggestions as an amicus curiae and things of that sort, which is I think a very effective way of being able to influence policy kind of decisions. So I think that pretty much sums up in terms of how you can bring about
Right.
policy changes from our perspective. It may be different for another player?
No, I mean, I feel like it's kind of been similar for us as well, like a sustained, effort to continue to talk about the issues that, that you care about, and then, engage with the system as and when that's possible.
Yeah.
In terms of like engaging with the system, we also wanted to know if you have had any experiences in perhaps doing some like sensitization trainings or something of that sort with, say, prison
Yeah.
authorities, court officials,
Yeah.
etc., as to how to, engage with, say, certain vulnerable groups when they are coming to the system. And I mean, in terms of these sessions themselves, or in terms of like these sensation programs that the court itself a lot of times initiate, what are some of the like the major gaps that you see, perhaps, that in terms of identifying what training is necessary, what are the some of the gaps that perhaps the courts also don't understand to ask for? And I mean, if so, have you come across any courts or anything of the nature where these kind of training programs are being regularly conducted? If not, how do we perhaps bring in again this policy of constantly engaging, constantly getting trained, constantly getting sensitized to the needs of vulnerable groups?
So my own take on this is that training can only achieve so much. You cannot expect systemic change coming through training. uh, Training can sensitize a few people in the system. Largely speaking, you have in the system, you have people who are die-hard optimists. They will continue to try and do their best irrespective of whatever challenges they have in their system. Then there are those who will do only that much which their bosses want them to do, right? So if you have a good boss, they'll do a lot. If you have a boss who doesn't care, then they also won't care. And then you have the cynics who think nothing is possible, and a very small percentage of people who are worse than being cynics. They are actually ensuring that no good thing comes out of their work and other people's work. That percentage is, I would say, very small, but largely you have, this is the continuum of people in the system, and this is true of probably all people working in any profession. Now, how much would training affect? You see, in any training program, the enthusiastic ones, you are mostly working with the converted. So you are getting in touch with people who are anyway enthusiastic, who want to bring about change. You get to meet them, you get to interact with them, you build networks with them so that they are useful to you in future. Then you have a set of people who are listening to you, thinking that, okay, these are good people, they are telling us something, I may take something back with me. And then there are people who have come there because they just want to change. This is the profile of trainees who come for any training program. We have done a lot of training in all these years. In these 35 plus years, we have done training of police, prison and judiciary at the state level, and personally at the national level also. I have been a resource person at the National Judicial Academy for a good period of time, in about 8-10 years back, but now for some reason I'm not being called, so that's okay. But most of the other places, state judiciary, we are regularly going for the Maharashtra Judicial Academy on various issues relating to release on bail, personal bond, probation of offenders act, etc. With the prison, we are regularly doing various kinds of sessions, for which we have an ongoing kind of a almost a syllabus which we are working in jointly with the Maharashtra State Prison Academy. The JOT is Jail Officers Training School, Training College, etc. So training is happening, okay? But the problem is that if you are not filling the gaps in the system, training can only achieve so much. When you have 30% vacancy in staffing, how are you expecting these people to become like saints? They can't. There's so much pressure on them, there's so much stress on them, that it's quite unnatural to expect that they would be very sensitized. So I'm not saying training is not required, but along with training you need to make sure that there is enough resources available. There are human resources available. You are serious about training. look at the state of training academies within the system in our country. If you look at all these, except when you talk about NJA or when you talk about NPA, you leave them aside. But you look at the normal college of training of police constables, or you look at the training academy of sub-inspectors, and you will find there are very few academicians in these universities, in these academies, sorry. They're all their own ilk who are training. There is no wind flowing from outside. You at the most call some guest lecturers, but you don't have permanent faculty who are sociologists or criminologists or law people, because you don't want to invest. You don't want to invest because you think it's a waste. I don't know what they think, but I don't understand why training is not taken seriously in our country. Training is not taken seriously, research is not taken seriously, and changes come about in this system purely because some extraneous reasons, not necessarily generated from within the system. Like the system is finding out something is not working, and then they're taking it up at the policy level, and the policy is looking at it, there is an exchange taking place, and then systemic changes. No, that's not how it takes place. If there is a huge riot tomorrow and lots of people die, then the police will be able to make a claim for more police, because and then the government will sanction also more police stations. After the 92 riots, Mumbai police was able to get some 10 or 15 new police stations, because they were able to make a claim that we did not have enough police to control the riots, right? So most of the time, this is the biggest systemic reform took place after Nirbhaya. In terms of legal reforms, crimes against women, that happened after Nirbhaya. It could have happened otherwise. There are enough people within the system who know enough and more in terms of what needs to be done. I think Priyambada has got frozen.
Can you still hear me? Or
I can
is
hear
it
you.
only the video?
I can
Okay,
hear
then
you.
I think maybe the video is just the issue, because I also just noticed it.
Okay.
But I think perhaps we can also we have spent a lot of time,
Yeah,
so thank you so
I know.
much for taking so much time out. I think maybe we can end with just one final question that we had, and it's a bit it may seem a bit reductionist, but just to sort of wrap things up on a certain note, we wanted to ask you if you were given the chance to completely design a criminal court tomorrow, what would be the most important, two or three most important features that you would say have to be kept in mind when designing this ideal?
Okay. Since I'm a social
Perhaps changed. Sorry, what is the most important thing that
yeah.
needs to be changed, I think?
Since I'm a social worker, I will say that you need to appoint social workers in all the wings of the criminal justice system, because they can act as a bridge between the people who are being processed, and the system whose job it is to process people. And we have seen the impact of this in those little pilots that we have been doing over the years. We had a pilot project some years ago where we appointed social worker to sit in the Metropolitan Court, Chief Metropolitan Magistrates Court, with the permission of the magistrate, Chief CMM himself. And we were given a table and a chair and a "may I help you" desk. And the number of people who came there asking for whole lot of questions, including where do I go and pay this fine amount? I don't know where to go and pay this amount. Simple things like that. There was a time when, in the month of June every year, students have to get their domicile certificates made to get admission into colleges from the local quota. So there was a time when one of the CMMs, who went on to become a high court judge, he asked us, give me a team from Prayas to man all the courts where domicile certificates are being made, because lawyers are making a lot of money there, and we want to just put up a table and a chair and a board which says what do you need to bring with you when you are getting your domicile made. And the payment to be made was in that time some 2 rupees or 5 rupees. And for 1 month we provided like some 15 or 20 volunteers, all social workers on Prayas, who were manning these different courts. There were some 7 or 8 courts where domicile certificates were being made. And it made a huge difference to the system. In fact, in one of the court complexes, the lawyers, the local lawyer association, they came and tore our posters and they overthrew the tables. So to that extent, we were affecting their income. And when we went to the CMM to complain about it, he said, "जाने दो, वो कोर्ट में छोड़ देते हैं, दूसरे जगह काम करेंगे." So wherever we can bring about, an interface between the public and the system, and who is a social worker? He is or she is a trained person who has knowledge of working with people, skills to work with people, and has information and knowledge about government programs, schemes, laws, procedures. So you need this kind of a person. If they, in fact, we feel that if there was a scheme within NALSA, just like you have appointed paralegal volunteers, every DLSA office should have 2 social workers appointed, either on a full-time or a contract basis, and they should be properly trained in terms of what their job would be. And anybody who comes to the court, these people can help them to kind of, including, it would be an asset to the magistrates and the judiciary when it comes to filing, let's say, a social investigation report, in cases where they want to decide on a bail matter. Because we have had these kind of examples where, magistrates have referred cases to us before deciding a bail matter. Said, go and make a home visit, find out the situation of the family and give us a report, and on that basis we will decide whether to release this person on bail or not. So there are so many innovations that can be tried out, provided this kind of a thing can be put in place. And the second one, I would say, is to strengthen our legal aid system, make it more reachable to people, and more accessible, and better quality of legal aid lawyers. I think these 2 things would really make a change in the system.
Thank you so much, Professor Raghavan. Thank you for so generously sharing your insights and your experiences with us today. We truly appreciate, the time, thought, and like your expertise that you have brought to this conversation. And also, we are very grateful for your contributions as we also continue to working towards, creating or helping facilitate a justice system that is perhaps more inclusive, equitable, and truly accessible for all diverse users in India.
Thank you.